all right. We are going to get into some non-sad news because we actually got good news. After the last video that was kind of tough hitting, let's go ahead and cleanse the palate with some pro Second Amendment news that will make you guys very happy. And this deals with Florida and open carry. It was argued by a friend of the channel. I'm should try to get him on here sometime. Eric Friday. Eric Friday is a good guy. He actually helped me out a couple times, and we're going to jump into this. Actually, let me go ahead and text him and say congratulations, Eric Friday. But yeah, he was the attorney of record on this case. So let's go ahead and jump into it. Okay, so Eric Friday is a friend of the show, and I'm gonna go ahead and I'm just going to link him this video so you can check it out. But this is a pretty cool case out of Florida, and it deals with open carry of firearms in Florida. Um, so we're gonna jump into it there, and yep. Give me 1 second here. Okay. So in Florida, you're not allowed to open carry. The only time that you're allowed to open carry is when you are fishing or hunting, which makes absolutely no sense. But in a recent decision, Florida have decided that, according to Florida, have decided that that is unconstitutional. So we're going to go through this case. It's only 20 pages long, and it's McDaniels versus the state of Florida, and it was on appeal from a county court. So this is a state court, and it's in the First District Court of Appeals of the state of Florida. Like I said, Eric Friday was the guy who argued it. Very smart guy. He works very closely with the Florida gun rights group down there, Florida Carry. So let's go ahead and read it. Florida law generally makes it a crime for ordinary law-abiding citizens, adult citizens, to carry a firearm openly in public. Stanley Victor McDaniels was convicted under that law, and now he appeals. He contends that this open carry ban is incompatible with the Second Amendment guarantees of the right to bear arms, guided by the Constitution's text and this nation's historical tradition of firearms regulations. We agree. Therefore, declare the law unconstitutional and vacate McDaniel's conviction and reverse his sentence. So basically, McDaniels was found guilty of carrying a firearm, and the courts have said that that is unconstitutional. We did a huge video on Charlie Kirk earlier. You should be able to find it on the channel. Florida is an outlier, along with California, Connecticut, and Illinois. It is one of the few states that generally prohibits open carrying of firearms. Enacted in 1987, which was way farther from the founding era than anything else, makes it unlawful for any person to openly carry on or about his or her person a firearm or electronic weapon or device. That means you're not allowed to open carry stun guns or anything like that either. A violation is a second-degree misdemeanor punishable by up to 60 days in jail and a fine up to $500. For those licensed to carry concealed, the statute permits the brief and open display of firearms provided it is not intentional, displayed in an angry or threatening manner, not in necessary self-defense. Basically, that is saying that if you accidentally show your gun like you've been down and it's shown, they cannot charge you with open carrying. And then it goes into talking about the narrow exceptions for hunting and fishing, which we already talked about. So it says, as a practical matter, then Florida law criminalizes the open carrying of firearms by ordinary law-abiding adult citizens in their daily life. So in July of 2022, McDaniels stood at a major intersection in Pensacola with a copy of the Constitution in his hand, open carrying a firearm. So what they charged him with was open carrying a firearm. He's not a career criminal, and he got arrested to make a point. He was convicted, but now he looks like he might be getting, well, he's definitely getting off. So they arrested him after they let him go at first, but then they arrested him later. So he was sentenced to probation. Then it goes into what the Second Amendment is. Then it goes into Heller. You know, Heller basically said that the right to bear arms is a personal right. It is a right of the people and not just the militia. People like Kamala Harris try to argue that only the militia had the right to carry firearms. The militia, in her opinion, was the National Guard, which was kind of weird. And then it goes into a little bit of Bruen down here as well. So it just goes through everything and it talks about the Thomas decision. It goes into McDonald as well. McDonald versus the city of Chicago is another groundbreaking case out of Chicago. So after they do all this, it said, applying the two-step framework, the Supreme Court first held that Florida open carry ban burdens of conduct within the scope of the Second Amendment because it restricts the manner of one bearing arms for self-defense. At the second step, the court determined that the ban related to the core of the right since it's limited to public carry where a need for self-defense exists. But it concluded that the restriction was not so close to the core as to foreclose the ability to protect oneself, given Florida's permissive shall issue concealed carry licensing regime, viewing it as not a burden as not severe as applied in immediate scrutiny. So basically, what they're talking about is a case before the Bruen decision where they said since you're allowed to concealed carry, you don't really need the right to open carry, and they applied intermediate scrutiny to that. Intermediate scrutiny is also known as interest balancing. Now, and the Bruen decision, Justice Thomas said that the Second Amendment is no longer a Second Amendment right and said that intermediate scrutiny is not a thing. So basically, the Supreme Court rejected intermediate scrutiny and took away the court's ability to use intermediate scrutiny in gun cases. So basically, what the state was relying on is a case that used intermediate scrutiny, which basically the Supreme Court said you cannot use that. So, with these principles in mind, return to Florida's open carry ban. We first address why we are bound to apply the analytical framework reaffirmed by the United States Supreme Court in Bruen rather than simply adhering to the earlier holding that the Florida Supreme Court in Norman. We then apply that framework to the facts of this case and conclude that the state has failed to carry the burden to show that Florida's open carry ban is consistent with the nation's historical tradition of firearms regulations. So they're saying we're not going to look at this other case, which Florida wanted us to look at, because we were going to look at this case through the eyes of Bruen, since the other case relied on interest balancing to actually pass it. And it gets in a little bit of the supremacy clause. The supremacy clause says that federal law outweighs state law, and the Constitution is superior to state law here. This is here McDaniels challenged Florida's open carry ban solely under the Second Amendment to the Constitution of the United States. He raises no independent claim under Article 1, Section 8 of the Florida Constitution. The United States Supreme Court has not directly addressed whether Florida's open carry ban violates the Second Amendment, although Florida Supreme Court upheld the law in Norman. It did so under the two-step framework expressly rejected in Bruen. That's them doubling down, saying that the Norman case did not use any of the Bruen standards when they decided the case because it was before Bruen. For therefore, that case is not really useful in determining whether this is constitutional or not. So I guess we therefore began, as the Supreme Court has directed us, by asking whether Florida's open carry ban regulates a conduct covered by the Second Amendment's plain text. If it does not, the law falls outside the amendment's scope. If it does, however, the conduct is presumably protected. We must then ask whether the state has carried the burden to show that the ban is consistent with the nation's historical tradition of firearms regulations. We address each question in turn. So basically, the right of the people shall not be infringed. Basically, let's go ahead and break that down. The right of the people to keep and bear arms shall not be infringed. Let's go ahead and break that down a little bit. The people, by the court's standards, are members of the political class, which are at least Americans that have read that have who have risen to the age of the majority. The age of the majority in the United States right now is 18. So therefore, McDaniel definitely does fall under the age of the majority and therefore is definitely part of the people. What are bearable arms? What are arms? The Second Amendment, according to the courts, protect all bearable arms that are in common use. Common use. I wish they would just say all bearable arms, but in Heller they did say common use. Handguns are bearable arms that are in common use, and that is exactly what McDaniel had on him. So therefore, the arm in question was a protective arm, or was a protected arm, which means that his conduct was presumably constitutional. Now we get into the second step, which is the nation's tradition of firearms regulation, the historical tradition of firearms regulations. What happens here is the burden shifts to the state, where the state has to provide historical analogs to show that a law is consistent with the historical tradition of firearms regulations in the country. And the state did not do a very good job of that. Because the Second Amendment's plain text covered the open carrying of firearms in public, Florida open carry ban is unconstitutional unless the state can affirmatively prove that the restriction is consistent with the nation's historical tradition of firearms regulation. To meet this burden, the state must establish that Florida's open carry ban is relatively similar to laws that our tradition is understood to permit. Okay, Rahimi, they said a historical analog does not have to be a dead ringer or historical twins, but it has to be relatively similar to the law that they're trying to use to defend it. You'll see a lot of times where these anti-gun attorneys try to use laws that have nothing to do with the carrying of firearms to try to justify a law. The historical inquiry is further constrained by two guiding considerations. First, because of our adversarial systems, courts do not resolve historical questions in the abstract, but instead adheres to the principles of party representation. We therefore decided this case on the historical record the state has produced as the party bearing the burden. It basically says the court doesn't have to go look for it, and the defendant or the plaintiffs in the case, they don't have to provide the historical analogs. The state does. Second, in reviewing the state's historical record, we are mindful that not all history is created equal. As the Supreme Court emphasized, constitutional rights are enshrined with the scope they are understood to have when the people adopted them. The founding era, 1791, the ratification date of the Second Amendment. So it talks about that. At the same time, the public understanding of the right to keep and bear arms in both 1791 and 1868, because some of the anti gun people try to say that the founding era is the ratification date of the 14th Amendment, which was 1868, which was during Jim Crow times when they wanted to stop formerly enslaved people from getting guns. So they passed a bunch of gun laws. And that's why they always try to push that. We are now an open carry case. Okay. At the same time, the public understanding of the right to keep and bear I already read that, sorry. Importantly, evidence from those periods carry the greatest prohibitive rate. On this record, the state has failed to carry its burden. It identifies no founding era law that broadly prohibits the open carrying of firearms in public, nor does it cite any historical regulations imposing a burden or justification apparent comparable to Florida's open carry ban. At most, it has pointed to laws regulating the method and manner of carry, but those laws left intact the ability to bear arms openly for peaceful purposes. In contrast, Florida's open carry ban eliminates that option altogether and thus extends far beyond any recognized historical condition. So basically, what they're saying is the state cannot provide any historical evidence that shows that in the founding era that the open carrying of firearms was verboten. They did try to use Northampton law, which is a 1328 law from England as their example, which, if you don't know, that was hundreds of years before the founding of the United States. I don't understand why they try to cite that, but that Northampton law gets cited a lot. I've noticed it a lot here, and I don't know what it is. All right, so let's move on here. So basically, right, what they're doing here is they're tearing down all the laws. They use like late 19th century laws to try to justify their ban, which was way too removed from the founding era. So it basically just tears it down and goes and talks about why the historical record from the relevant periods do not show that the law is constitutional. I'm just going to read this paragraph. In sum, the historical record from the relevant period shows our nation did not regard concealed carry and open carry interchangeably. Florida's like, hey, we allow people to do concealed carry, so they don't need to open carry. But what they're saying here is that in the founding era, that was not the case. They viewed them as separate things, and neither one were banned. So the plaintiff, or the defendant in this case, um, won because his conduct was presumably constitutional, and the state did not meet its burden to prevent historical record. So what they did is they reversed the judgment and his sentencing was vacated and they remanded it back down to the court. Now, what's going to happen here is it's going to go back down to the court that convicted him, and the court is going to have to rule the way that the appeal courts said. So they have to take this verdict and they have to basically find him not guilty. This is a good win, and Eric Friday is a great guy if you're looking for an attorney in Florida and you want a gun issue. Eric Friday is one of the people that you really, really need to contact. With that, we're going to get out of here. Just wanted to make a quick video and let you know what's going on here. I will see you guys later.